So welcome to the October 26, 2021 Zoning Board of Appeals meeting of the Town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I'm now going to do a roll call. I'll start with you, Patricia, then go to you, Tom, and then we'll wrap up down here.
Okay, Patricia Beaton.
Tom Hennessy.
Greg Dean.
David Murch. This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you are unable to see or hear. The board works from a published agenda and will be considering tonight's items in the following order. Number 1, call to order. Number 2, approval of minutes of the September 28, 2021 meeting. Old business, which was tabled on September 28, 2021 for Port Harbor Marine. New business, public hearing on applicants Sarah and Matthew Holland for a setback reduction. Number 5, code enforcement communications. And then finally 6, shoot, I had to fill it in. Adjournment, there we go. It's not on my agenda, I had to throw it in there real quick. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual right to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to stand at the microphone, to sign the speaker's sheet, state their name, address, and affiliation with the application, being either for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chair. This meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside the meeting room. And I will also mention that we are under our remote participation policy tonight. We have 2 board members that met the conditions for us to have a remote meeting. As such, any votes that we do tonight, we will do by roll call. So, next up on our agenda is approval of meetings of September 28, 2021 meeting. Do I have a motion to approve those?
I'll move to approve.
Move to second. Any
I'll
discussion?
second that.
All right, any discussion? All right, we'll go ahead and vote on that. Patricia, you can lead us off. You all in favor of the minutes? Patricia?
I agree.
Tom?
I agree.
Greg?
Agreed.
Favor as well. So, old business, table on 9/28/21. Application for Port Harbor Marine, Inc., location 1326 Roosevelt Trail, commercial zone, appeal for conditional use of outside storage. It took a motion to put it on the table, so I now need a motion to get it off of the table. Can I get a motion from someone?
I moved on table.
Can I get a second?
Second.
Any further discussion? Patricia, vote to take this off the table, yes or no?
Agreed.
Tom?
Agreed.
Greg?
Agreed.
David agrees. So, as a reminder, we are looking at conditional use for property located at 1326 Roosevelt Trail, map and lot of 51-2. And we had gone through the land use ordinance, specifically Article 9 for minimum standards, Section A for conditional uses. We had reviewed 10 items there, numbered 1 through 10. We, as part of our discussion on the 28th, we as a board discussed and voted informally on items 2, 5, 6, 7, 8, 9, and 10. And we had open questions, which resulted in the tabling of this application. We had questions with regards to item number 1, item number 3, and item number 4. So tonight we will hopefully have a chance to discuss these more. So item number 1, which was left open under, again, Article 9 of the Land Use Ordinance, Minimum Standards, Section A, Conditional Uses, states, will not depart from the general purpose and intent of the ordinance, nor from the town's comprehensive plan. So as a reminder, we're looking at as commercial space being proposed use of outdoor sales and service. And we as a board weren't 100% sure that this use of as outside sales and service would fall under the town's comprehensive plan. I did have a chance to review the comprehensive plan. I don't know, Alex, if you wanted to provide us, what you were able to.
Yeah, I did look at, go through the comprehensive plan, and I don't think that there's any issue there with this. I think that it kind of hits quite a few of the bullet points for the commercial zone. I think it's harder to argue against it, to be honest, for the commercial zone portion of it at least, which is what we're here for.
Right.
And I don't disagree with, the points that he's made in the submittal either. I mean, I think
Yep.
that's pretty much what I found.
Yep. Yeah, I had a chance to review it. I agree. Everywhere it said commercial, it seemed to
It's pretty
lend
open.
itself
Pretty open, yeah.
specifically to what the intent was tonight.
Yep.
The only thing that I found interesting was on section 910, the use of outdoor sales and service. It wasn't noted as either a permitted or a conditional use. Which I thought was interesting, but clearly in the land use ordinance, it is a conditional
Yeah,
use.
I don't know where the
commercial.
disconnect was on that, but I guess it doesn't really matter much if it's in the ordinance.
Right.
Yeah.
So Patricia or Tom or Greg, do you have any further thoughts in regards to this item or anything that you wanted to discuss?
No, I think the fact that we did look into it, with all the people that came to the meeting last week, with a lot of objections, and we did a due diligence with regards to extra information to make things clearer.
Agreed. Anything you wanted to talk about, Tom, with regards to this?
No, I did a quick review of the comp plan, and it seems to encourage development in the commercial zone. So I agree with the other statements.
Okay. Greg?
No, I think defer to Alex is kind of my position, and it seems like he's done a comprehensive review of the comprehensive plan now, so we're double comprehensive.
Yep. Okay. So I agree with that. So we'll just take a quick informal vote on this. Do we agree that item number 1 for a conditional use standard has been satisfied? Patricia?
I agree that it has.
Tom?
I agree.
Greg?
I agree.
And I agree as well. Item number 3, will not generate noise, vibrations, fumes, odors, dust, or glare which are detectable at the lot boundaries, and all aspects of the conditional use will be carried on within the structure. We set this item aside because of that last statement of being carried on within the structure. We had asked for feedback from the town attorney on that, and we did get a response. That response is from Phil Saucier, who stated the following. Outdoor sales and services are allowed in the commercial district as a conditional use, but the term is not otherwise defined. In construing the terms of an ordinance, the Maine Supreme Judicial Court has held it first evaluates the plain meaning, and if the meaning is clear, need not look beyond the words themselves. It further construes the terms of an ordinance reasonably, considering its purposes and structure to achieve a harmonious result and to avoid absurd or illogical results. While the conditional use standard does contain a criteria that all aspects of the conditional use are carried on within the structure, it is not reasonable to apply the provision to outdoor sales and storage, since it's by very term necessarily means the use occurs outdoors and not within a structure. Thus, in my view, the criteria simply does not apply to this particular conditional use, although the first part relating to noise, vibrations, etc. does apply. I would have to agree with that. My only concern is that we do have a conditional use of outdoor sales and service. I just want to make sure that we feel comfortable that outdoor sales and service means actually sales and service that occurs outdoors versus perhaps outdoor equipment or outdoor services which can be sold or done within a structure. So to that end, I did ask Alex if we had any examples of a conditional use for outdoor sales and service being granted for commercial use. Did you?
I'm not aware of anything.
Okay. Now
No.
we do know for the lot across the street. Yep.
Yeah, which we had discussed last time. But other than that, I don't know of any.
Right.
Yep. That's a tough one to really research, because there's no way to search the records for it.
Yep.
So I'm not aware of any. It doesn't mean that there aren't any out there, but just not anything that I was able to come across.
Right.
I don't know, Sandy, is that something that you happen to know? No.
I haven't seen anything.
No.
So I thank you.
Yep.
I guess as a board, I just want to make sure that we feel comfortable what the definition of outdoor sales and services is. I'm comfortable with that being what is proposed, which is the storage of product outside, which can then subsequently be sold. And then also the idea of shrink wrapping boats, or having those left outside and stored on property, that seems to be an outdoor service to me. So from my perspective, I believe an outdoor sales and service can be conducted as the attorney has suggested, but I would welcome any feedback to that.
I don't have any feedback.
Okay. Does everybody feel comfortable with the definition of outdoor sales and service being, what's proposed by Port Harbor Marine, which is product outside and sales and services that are outside of a structure? Are we comfortable with that?
I am. Is there any way just to put a condition that it doesn't exceed that? What we believe is, what we are understanding is going to transpire with regards to the outdoor sales and service?
You guys can apply conditions if
We
you would
can.
like. Yep.
So, I don't know if you heard Alex, but yes, Patricia, we can put a condition to that effect.
I think that might be something, if everybody agreed that might be a good idea.
I personally would agree to that, given the fact that I could potentially question as to what outdoor sales and services are. So if we want to sort of fine tune that decision, I think that would be a good idea. At least it makes it clear as to what we as a board are approving tonight.
Okay.
Would Greg or Tom, would you agree to that, disagree to that?
Yeah, I agree with that.
Okay.
Yeah, I agree.
Okay. So, so we don't need to worry about the carried on within the structure, but we do need to confirm that the proposed use will not generate noise, vibrations, fumes, odors, dust, or glare which are detectable at the lot boundaries. So I'll open that up to comment.
That's number 4.
Well, we're still on number 3.
Still on number 3. So if we put the conditions with what you had pretty much listed with regards to sales, the shrink wrap, you know, that limits what we're understanding that is going to transpire, and those could be the conditions which would alleviate any of this in as far as the odors, fumes, dust, etc., if there's just sales and the shrink wrapping and storage.
Yeah. Rob, I will ask if you can just come up. Alls I want is just confirmation of you of what the proposed use is for the commercial strip only. Can you just confirm how Port Harbor is looking to use that in terms of outdoor sales and service? I just want to make sure that we're not putting a condition on this that limits you from what the original intent was for that commercial strip.
As they have used on the other parcels, sales, storage, display, and marina-like uses.
When you say marina-like uses, what does that?
Well, that's a catch-all, because I don't know everything they do. I apologize, but mainly the area along the front, that's their vision that people see coming into the area. Mainly, they're going to be putting product out there during the season. You know, I can't see them doing a lot of service. They may go out there and start or tinker with something, but their main maintenance would be back in one of the buildings or whatnot. So when I say marine-like activities, they may do something with a boat out there. You know, like change out an engine, take an engine off, put an engine on, or something like that.
Okay, thank you.
Yep.
So for number 3 then, we'll be comfortable with approving this as long as we add the condition that the activity for this conditional sales and services is limited to product display and storage and services under marine-like uses. Are we okay with that, or is that a little too vague when it comes to the marina-like uses?
I personally find that vague.
Yeah, I kind of do too.
Yeah, some of it's self-evident until you get to marina-like uses, and then I feel like it becomes pretty open-ended.
Yeah.
I mean, it may be easier for you guys to say what you don't want. Like if you don't want engine repair work to be done out there, or maybe it's if they do engine repair work that it must be done indoors and not outdoors, in more of a controlled environment. It might be easier, instead of listing all the things they can do, to just prohibit, you know, in that marina-like uses. Obviously you'd be fine with them shrink wrapping and probably doing some general cleaning and maintenance, but it's probably not, you don't want them ripping open a boat out in the front lawn there and having it exposed to the elements and stuff, which they probably wouldn't do, but you never know.
And just to confirm, if we approve this tonight with conditions and Port Harbor Marine, for whatever reason, let's go with this property in the future, the conditional use runs with the property.
Correct.
But the conditions we put on it also run with the property.
Correct.
Okay. So it makes sense for us to put those conditional uses
Yes.
on that way. Okay. Yeah, Rob?
Well, isn't it covered by the use, to some extent? Like, it's commercial by default, right? So quite a broad set of activities are allowed.
Yeah.
So this criteria that we're evaluating is only for kind of the change in use.
Yeah. Because it's a special
Right.
consideration.
So I'm not sure how, like, the conditional use is outside storage, so how does marina-like activity apply to that?
I have outdoor sales and service.
S-
So,
Okay, just like,
kind of
yeah,
the service piece. Yeah, I can't go by
okay.
that.
So it's
Rob,
the
if-
service.
if you have something to add specific to what we're talking about in terms of the servicing.
I would say minus major mechanical repair. Would that satisfy the board?
I think we're probably looking at even minor mechanical repair too. So, I
Well,
mean,
the thing is taking a part off a boat and replacing it, you know?
How about we just say minus mechanical repair that would generate noise, vibrations, fumes, odors, dust, or glare, which would be detectable from outside the lot boundaries.
I like that,
Is that fair?
Yeah, I
mechanical.
think that's fair. Another thing too to keep in mind, in the commercial zone, auto repair facilities are allowed,
Wow,
excluding auto body repair. So actual body work is not allowed, but
but those are,
repair services are.
so other repair services are allowed.
but those would be happening within a structure, I would assume.
We would think, yes. Yeah.
Yeah, I think it's just hard to predict the future for everybody involved here. So as long as we can just have some condition that says, you know, clearly the conditional use is not in violation of 3, which is pretty clearly outlines the intent.
So, we said, number 3, which, with the conditions that it would be for product storage, product display, and marina-like uses which will not generate noise, vibrations, fumes, odors, dust, or glare, which are detectable at the lot boundaries.
Yeah.
Would we be in all agreement to that? Patricia or Tom?
Is there any way to say that any kind of maintenance happens within the structure and not, you know, like, not shrink wrapping, but if it's doing engine work or whatever, it's within the structure, not outside?
How about we say, allow for storage and display and marina-like usage, which blah, blah, blah. However, engine repair services are not allowed.
Maybe outdoor engine repair
Out-
services.
Outdoor engine repair services.
Because technically with this, you guys aren't really approving indoor use anyways. It's
No,
outdoor.
I
so-
don't, I'm not looking to do that.
Right.
Would that be reasonable? Would that work for you, Patricia?
Yes.
Okay. So no outdoor engine repair services. However, storage, display, and other marina-like uses which will not do these things.
And we listed that.
We'll list out what's in number 3.
Okay.
Tom, does that have any thoughts for
Yeah,
that?
I'm in agreement, because there are plenty of things they do on boats that don't cause noise and vibration, like
Yep.
changing out the bimini top on some boat or something.
Sure.
You know, a simple thing.
Yep, I would agree with you. Okay.
Yeah, I agree.
So for number 3, do we agree that this item passes as long as we add the condition of product display, storage, marina-like usage, which will not generate noise, vibrations, etc., and no outdoor engine repair services? Patricia, would you agree
Agree
that,
with that.
Tom,
I agree.
Greg?
I agree.
I agree as well. So the last item that we had was item number 4, will not cause water pollution, sedimentation, erosion, or contaminate any water supply, nor reduce the capacity of the land to hold water so that a dangerous or unhealthy condition may result. Part of that comes as we fall back to the paragraph leading into conditional uses. We felt that it's indicated there that the applicant shall have the burden of proving that his or her application is in compliance with the requirements of this ordinance. Therefore, we did ask for additional information from Port Harbor Marine, which Rob did provide. Thank you. I'll go ahead and read what was provided to us. So as indicated in the conformance with the comprehensive plan listed above, the project will be designed so that the site does not cause water pollution, sedimentation, erosion, contaminate any water supply, nor reduce the capacity of the land to hold water. More specifically, as the site is developed, it will be designed to treat any runoff from additional impervious and developed areas. As part of the sketch submitted for the board's reference, we indicated the potential location for stormwater treatment for the development of the property. The northern corner of the property adjacent to Roosevelt Trail slopes southerly to about the midpoint of the property, where the balance of the property slopes to the west-northwest towards the body of water that is shown in the sketch. This surface water is hydraulically connected to the lake. Surface water after design of the site will continue to flow in this direction as indicated by the flow arrows added to the sketch. The proposed design of the property will utilize the proposed treatment areas shown in addition to the additional treatment areas on the site. These additional treatment areas will be either a surface area filter, subsurface filter, or a proprietary filter design system to meet water quality and phosphorus treatment and reduction as required by the state of Maine stormwater law. We have completed some preliminary calculations and indicated these areas on the sketch previously prepared. In addition to indicating this treatment on the plans, we have indicated the location of silt fencing, erosion control berm that would be used during any land disturbance or construction to control erosion and sedimentation from the property. Although not required for the submission, we've added all adjacent structures within 100 feet of the property. The above referenced design standards will need to be met for approval by the town and Raymond Planning Board and the Maine Department of Environmental Protection. So I have had a chance to review the sketch, which I appreciate was being provided. So I open this point up now for discussion among the board.
Yeah, I guess I don't know. I know that there's we've done the public comment and whatnot, but I was hoping that you, Mr. McSorley, that you could take us through the drawing and as it's described and I don't know if you have a visual you can put up, everybody, but just so we can all discuss it here in this forum as well.
Do we need to put it up? Do we need to put it on the?
Let me ask this first. Patricia and Tom, do you have copies of the updated sketch that was provided? Patricia, you do? Tom, did you get a copy of it?
Yes, I've seen it.
Okay. So
maybe we don't need to put it up.
yeah, that's fine. For the people here present, we're good.
As the board had requested, we went back and we actually did some preliminary calculations for the site. MDEP and town requires us to look at any newly developed areas, whether they're impervious or pervious in nature. A lot of this will probably still remain grass after the development is done or the changes are proposed or whatnot. However, based upon MDEP criteria, they say that if you do outside storage on grass-type areas, they basically want you to assume it's impervious. So we basically assumed a large amount of impervious on the site, basically 80%. I don't know if we can even get that with, the buffers and whatnot, but we did that and we came up with the volume that we needed for water quality treatment, and then divvied that up into the maximum size areas that we could do for treatment. And that's why we kind of showed 2 areas there, which are towards the lower part of the site where the water would be channeled to or intercepted, and then we would put some type of treatment device there. Our preference would be an under-drain soil filter, which is a kind of a depression in the ground, has a filter media and a leach bed like a septic field under it, which takes the treated water and allows it to be discharged off-site. Similar things are subsurface sand filter, or there are proprietary devices that do a similar thing. So it would be one of those type of things that we would put in there. And so we wanted to make sure that we could size something appropriately that would take the worst condition that could possibly be put on the site. And that's why we showed that. We added flow arrows to show where the flows would go. Also discharge arrows from those facilities. We would discharge that water into an open area outside of the adjacent wetlands so that it flows freely with no erosion for the discharge. And then we showed where we would put our typical erosion control and sediment berm, which you typically put that all on the downstream side. We've added it up along the right-hand side of the property, or southern property line, which is the site over near Indian Point. There will be a 30-foot and 15-foot buffer depending on what zone the property is in to kind of protect that area anyway. But so that was basically how we looked at that for your response. I think in the main application, I may have mentioned that this site is also under a multi-sector permit, general permit, because of the use of the property being a marina. So there's another MDEP permit that covers the site relative to stormwater and storage of materials or any type of discharge that could be made off the site. So there's a whole document that will need to be modified as part of adding this additional property in that will cover that also relative to storage of materials on site. The fact that one of the conditions that you had relative to inside maintenance of engines, that's a concern. We don't want to do that outside where oils can get and then be carried off by water and whatnot. So that's another additional thing relative to the stormwater. So with that, any questions you have about that?
I think it's, one of my concerns here is it's pretty compelling. Like, you put the gets together, you're qualified, like, I don't, and we're kind of at the mercy of your explanation.
Yep.
It is somewhat alarming, and I want to say this as sensitively as I can. It is somewhat kind of gives me pause that, you're doing the work. You're here advocating for the work. And I believe you also do work for the town of Raymond. And we basically have to take your word for it. I know there's nothing in the ordinances that requires independent kind of opinions, but boy, it sure would be easier, given that everybody's looking at this and saying, like, how do you make decisions? And for us, anytime there is a conflict, we always want to have disinterested opinions.
Yeah.
That's why we're here, right? To be disinterested in the party, or in the decision. So that's I'm not taking a shot at you or the company. It's just, it's a little difficult if you see the kind of, anytime there's a potential for conflict, I would prefer that we go out of our way to avoid it.
Correct.
Now, there's nothing in the ordinances that say that needs to be done, but that's just something I think I should say, just put out there, that we're kind of at the mercy of all this information, and it makes it more difficult when it's all kind of the same. I don't know why. It's also maybe a little bit of my inexperience in terms of kind of an advocate for the applicant versus the applicant. Most of the people we deal with, the applicant themselves is advocating for their own, and the person that's doing the work, or the entity that's doing the work, is not, kind of involved, or their opinions aren't so much involved. So it's just something I want to bring up and make sure the board's kind of considering as they think this through. Like I said, I don't believe that there's anything in the ordinances. I mean, Alex, we did ping the town attorney on this. There's nothing in the ordinances that say this, but it does seem like there is a potential here of kind of optically looking bad. So it's something I wanted to address.
I can, I guess, give you a little bit of input on that too, because if you guys approve this, like we talked about at the last meeting, they still need to get planning board approval. They still have to go through site plan, and there's pretty strict standards on stormwater and all that good stuff. Sebago representing the applicant means that Sebago on the town's end is disqualified. So I think a lot of your concerns would kind of be resolved. What happens when Sebago submits an application is we actually get a third-party engineering firm to review Sebago's work.
I see.
So they're not looking at their own work. We have someone else that we hire to do that. So I think that probably takes care of a little bit of that, because we don't have a conflict there. I did talk with Phil on the phone about this, the town attorney, and his general impression was he wasn't concerned. And he wasn't concerned about, when I say that, I mean, he wasn't concerned about, I guess, the concerns with sedimentation, erosion, contamination, all that stuff specific to stormwater, because the planning board would be reviewing it. So he didn't want, and verbatim, he was basically saying he didn't want you guys to get too hung up on that, because there is additional insurance down the road with the planning board having very strict criteria that they have to follow for their approvals. So if they get past the first gate, there's a lot more work that gets done on the back end. So I can understand why you would want to give it a little bit more attention, but that's just some other things to consider, I guess.
Okay. No, that's definitely helpful. I think, again, most of it's because I'm just not qualified to vet any of this. So I hear somebody explain it to me, it's very compelling, and then I kind of also look at the large group of people that have adjacent. There's a large group of abutters.
Oh, yeah.
A third of it's wetlands. The abutters are all wetlands, and I'm kind of like.
You're saying, what am I missing?
Okay.
What am I missing? Yeah.
Yeah. So I just wanted to bring it up, so it's on record that it is something we discussed, and like I said, I don't think that there's particularly a statutory issue here. It's more of, have we considered it? And I think that you bring up some good points.
Okay.
Tom or Patricia, anything you want to add?
No, I think Greg covered a lot of that, and Alex was forthcoming with the attorney's statement, and it makes you feel a little better that the abutters, with what we do, won't be causing them in the future by a decision any undue hardships down the road, and it falls on our shoulders. So this has a ways to go. We're not the end all, but I'm comfortable now.
The other thing too to keep in mind, if you guys prove this with these conditions, specifically like the one we just talked about a minute ago, it does give the abutters the ability to submit a complaint saying that they are in violation of their approval. So if there are any issues with them doing stuff outside of what you guys are allowing, that it could become an enforcement action. So it does give the town a little bit of authority to take some action on that.
Does that require the conditions be added to the, like, approval of conditional use, or is it implied based off from the?
No, you can tack on additional conditions.
Okay.
Yeah, you can add on whatever you want there, yeah.
Yeah.
Well, not whatever you want, but, you know, within reason.
Right.
Okay. Yeah, like I said, sorry, I don't know if you,
Nope.
yeah, with respect, I mean, I think your description is fairly compelling. It looks like you guys have a comprehensive plan to handle what I think is perhaps the trickiest thing here is the water issue. And you know, it sounds like there's at least some conflict avoidance stuff in place, and I appreciate it.
Yeah, I would echo definitely what Greg said, especially in the sense that we did have a number of, abutters here the last meeting who expressed concerns in this area. But given that the information of what was provided, I do believe that satisfies criteria number 4. So with that said, would we as a board be in agreement that number 4 in this list has been satisfied? Patricia?
I think it has been satisfied. I just am thinking if there was some kind of condition that we could set, so this way, any of, the abutters there at Indian Point have some sort of door or recourse in case something does fall through. And we can't, as far as protecting their interests.
So I guess the question is, what does that condition look like?
Well, the fact that they're saying it will not cause water pollution, sedimentation, erosion, contaminate any water supply, etc. So in the condition that we're approving this, we're comfortable with what we're receiving with information, but the condition is we're approving it based on the fact that that doesn't happen.
Does that sound reasonable, Alex?
Yeah, I mean, and you also may want to just add on kind of a blanket condition that this approval, is contingent on them receiving all other applicable local and state permits required for this use. So that means that they are, by getting this, that they have to get planning board approval before they can do anything. They have to get any, stormwater or DEP permits, which you guys must have got a stormwater permit for the addition, the parking, or the boat storage area a few years ago.
No, that was not required.
Okay. Is there a stormwater permit for the marina across the street or anything, or a?
No, all of it to date has.
Use the mic, please.
I'm sorry. All of the projects to date have fallen outside of
Okay.
the MDEP stormwater criteria. We have a track
Yeah.
going on of the impervious area that we've either created or we've changed. And that was provided to the DEP with the last permit that we got from them. This project will probably trigger at least stormwater,
Yeah.
and it will be dependent on how far we go, whether we would trigger site law.
Yeah,
Totally.
DEP doesn't, because if this is a separate lot, they don't look at it as a separate lot. To them, it's all considered a common
Yeah.
development. So by them developing this lot, they kind of have to include everything from the other lots. So there are different levels of state permits. So I think kind of a catch-all condition that they have to get all of those that are required would be good.
That apply to the concerns you have.
Okay.
Yeah, I mean, that seems like a pretty reasonable way to kind of gate what's been said is what gets done.
Yeah,
as well.
I mean, if it can legally be done under state law through DEP and the town's planning board and all of the required criteria and conditions in the ordinance, then I think it can be done. But they've got a lot to do before they can get to that point.
Yeah, not knowing what all those things are.
Yeah.
I think to me it's like is can all those things be done, and it also reduce the land's ability to hold water. Like that's the combination of outcomes that I'm trying to
Yeah.
look out for, because I don't know what DEP requirements are, or what the
Right.
planning board requirements are. I'm just looking at in particular, what flags number 4 for me is the reduction of the land's ability to retain water. So like that's kind of the part of the number 4 that I want to make sure we protect. It's like,
Yeah.
are you putting burden on the abutter's land that wouldn't necessarily be covered by permitting from the DEP or?
Yeah.
Hey, David, I'm just gonna step out for 2 seconds. I'm coughing and I'm gonna get some water.
Okay. I gotta ask you this too then, Alex, because, I mean, I know we're talking about a strip of land for commercial.
Uh-huh.
And then we're also talking a bigger picture in which there's a significant part of property here being developed for a bigger. But if we're just simply looking at this commercial strip for conditional, use, I mean, is there any sort of planning board approval associated with that?
Yes, I mean,
Would there
regardless,
still be?
they would still need planning board approval, even if it was just the commercial zone, or even if it was just the shoreland zone.
Okay,
If you guys denied this, for example, they could go to the planning board to do everything on the lower side of this without coming to you, which is the side that's closer to the wetland, closer to the pond. So it's a little funky because that would be the area you wouldn't want developed, but they could actually just skip you guys, go to the planning board to do that, and not develop the portion on the front.
Yeah.
So that's why this is a little bit of a challenge here. So I don't know, does that answer your question, I guess?
well, let me ask this. It does, and I kind of thought of something else. So let's just say this gets approved
Yeah.
tonight. Can tomorrow they bring product out on that strip and
No.
we put it there? No. Okay.
No, that would still require a site plan approval
Okay.
to do that.
Okay.
Well, let's just say we don't put any conditions on it, and it does. Number 4 ends up being it does reduce the capacity of the land to hold water. Right? Let's just say that's an outcome. Everything's signed off on, but that's an outcome. Is there any action the town can take? Or do we need to have a condition in order for the abutters to have recourse?
They're going to need to treat any water that is additional stormwater that's created here. So if they're catching any additional stormwater, it has to basically be treated before it leaves the property for something like this. So that shouldn't be something that happens. You can add that as a condition if you want. If that's one that's...
I think I'm asking it something slightly different. I think maybe. But I believe you're right. I believe the DEP. I'm willing to take all that at face value. But let's just say that for some reason it goes wrong.
Yeah, sure.
Do the abutters have recourse outside, or do we need to have conditions added about
Nope.
number 4?
They could
That's all.
submit a complaint saying that they're in violation of the conditional use approval,
Okay.
and then the town would
So-
could take enforcement action.
So these things that are here are kind of implied in the
Yep.
conditional use anyway, so we don't need to
Absolutely.
add additional.
Absolutely,
Okay.
yes.
So it
Yes,
seems
you're
like
correct.
we're maybe being superfluous about how we append anything real, okay.
So if you guys approve this, there should be findings, and those findings should address 1 through 10.
Okay.
And in a perfect world, you would say why you feel it meets 1 through 10, which you guys are kind of doing. You're going through and you're talking about each one and agreeing, yes, we feel it does meet that. So it should be part of the conditional use approval that it meets 1 through 10, or you feel it will meet 1 through 10. And then if it doesn't, then they're in violation of that conditional use approval, and then you can trigger enforcement action and possible legal action.
Well, if that's the case, I don't think we need to add any conditions to it, to be honest with you. I feel like if it.
Yeah, I
if
mean,
it-
you guys can still expand on them though, which you've talked about doing, not allowing the
Right.
outdoor engine repair, stuff like that. You can tack on those above or expand on any of these if it's something that you want to do. You know, for example, adding something silly like they couldn't do it after 9 p.m., which, you know, and this one doesn't apply because it's, you know, they're storing boats all night long. I mean, they stay there for the whole season. So, but you can add stuff like that. I think right before you got on, right as you were joining, we had a conditional use that we talked a lot about adding conditions because there was a lot of concerns with a neighbor. So we kind of dove into conditions on conditional uses and how they stay with the land and everything. Because there was a lot of talk about adding a condition, but having it expire if the property owner sold the property. You may remember that, David. So we did spend some time with Phil on conditions for conditional uses. And you can definitely add quite a bit if you want.
I think as long as 4 has to be honored kind of into perpetuity and any deviation from it, because again, we're only really looking at the change in use here. All the bulk of the permitting and everything that's going to get done is going to be vetted by far more qualified people. To me, I look at it and say, again, I think the main thing is it seemed like overwhelmingly the largest concern from the abutters was potential change in water to their land. And I think as long as that kind of opportunity for recourse, if that were the case, kind of just is there implicitly, I don't think we need to add a bunch of permitting. That's just my opinion.
Yeah.
I'd like to hear.
Well, Patricia, you had, brought up that thought of adding conditions here. I'm in agreement with you in the sense that I want to be able to look out for the interests of the abutters. I also hear what Greg's saying in the sense that, it's already going to have to meet item number 4 anyways.
Right.
So I don't know. Is there?
I think with Alex's, the whole, as long as everything, all of the permits with the DEP, et cetera, are, compliant, adhered to, then that would be the condition.
Right, so just so basically no need to put a condition because overall this all has to be met anyways.
Right, because once it leaves us, it still has to go through all the other permitting.
And I think probably for you and I and the rest of the board, we can at least feel comfortable that the abutters can still file a complaint should they see that anything within items 1 to 10 are not being satisfied. I mean, I feel good about that, so.
As do I.
Okay. All right, so would we agree then that item number 4 has been satisfied as written? Patricia?
Knowing that they still have to go through the other permitting and that nothing can move forward without that, yes, I agree.
Tom?
I agree.
Greg?
I agree.
I agree as well. So we have reviewed all 10 items based on my notes. We were unanimously in agreement that all 10 items have been satisfied. So with that said, do I have a motion to grant a conditional use for this property for outdoor sales and service, but with the condition that it be limited to product storage, product display, and marina-like uses, with the exception that outdoor engine repair services are disallowed?
So moved.
Do I have a second?
I'll second.
Any final discussion? Okay, roll call vote. Patricia? Do you approve?
Approve.
Tom?
Approve.
Greg?
Approved?
I approve as well. So this has been passed.
Thank you very much.
You are welcome. Best of luck with all that. Okay. We will transition into the new business portion of our agenda. A public hearing for applicants Sarah and Matthew Holland, property located at Jordan Lane, map lot 3510, zone LRR1, request for a setback reduction. So is either Sarah and or Matthew here tonight? Both are. If one or both of you would like to go up to the podium, you'll have to sign in. And then state your name. And Sandy, you'll have to help me here. We need them to state their residence as well, where they're from.
No, just hear the property owners and the applicant.
Fair enough.
They're good.
Okay, so if you want to give us sort of a run through of what you're looking to do.
Great. So I'm Sarah Holland, this is Matt Holland, and we're here to request the setback reduction for the property at 33 Jordan Lane. Just to give some background on the property, my parents are the owners of 35 Jordan Lane, which is the adjacent property. It's a property that they've owned for over 40 years, so a place where my brother and I grew up. My mom grew up on Crescent Lake, and my brother and I grew up canoeing down the Tenney River to visit my grandparents and my many cousins, so it's become an incredibly important part of our family life and our summers, and my parents continue to live there summers today. And in 2000, the adjacent property, the one that we're talking about today, came up for sale, and we purchased that in hopes of kind of preserving this whole thing for our families in the future and being able to grow it, grow with another building as our families continued to grow, which did happen. In 2006, Matt and I moved to Maine with our 3 daughters, and my brother's family, he's also grown to have 3 children, so now there's 12 of us using the property. And so in 2016, we had it surveyed, and that's the survey that you all have in hand as part of our submission. That's when we really started realizing it was time to think about building another home on that property. And the last couple of years was that it really became something that we wanted to do. And Matt and I realized that we would like to make this our permanent, our full-time residence here in Raymond. We're soon to be empty nesters, and this is the place where we like to settle. So we started designing the home, came up with the plans, and then Matt came to talk to the coding enforcement officer this summer to show what our plans were. And we realized at that time that the survey done in 2016 had some misinterpretations of the Raymond Town Code. And Matt will talk about that part since he was here at that meeting.
I just came with Sarah's parents to the code enforcement, met with Alex. Hey, Alex.
You're there.
And we reviewed the survey. He went through the code and explained that they must have misinterpreted the front setback, which they had at 10 feet as opposed to the 30 feet. So with that 30-foot setback reduction and then the 100-foot setback from the water, that would leave us with about 6 feet of buildable space. So, that was a little bit disappointing at that meeting. Then Alex said that we could go before the zoning board to request the reduction to the 15-foot on the front, and then we're also looking for 10 feet to the side of Sarah's parents. So.
We did review that section 16, article 2, and saw that there are 8 different points that we have to meet in order to meet the requirements for the setback reduction, and we do believe that we meet all of those 8 points. So we're hoping to be able to get those setbacks and build a full-time residence and be residents of Raymond in the near future. So we look forward to any discussion and anything we can answer.
Do we stay here or?
Well, I think at this point, we can go ahead and sit down. We'll, what I'm gonna do next is, what we'll do is we'll open this up for public comment. And so in doing that, is there anybody here tonight, either via Zoom or phone or in person, who would like to speak? What's that,
There's
Sandy?
nobody in the waiting room. for
Nobody?
Zoom.
Okay. So is there anybody here tonight that would like to speak in favor of this application?
I'm not necessarily speak.
Sure.
Greg Perry, 31 Jordan Lane, so I'm the abutter to the,
Could you just sign that?
oh, sure, north side. And so we are not here against it. I'll tell that in a second. Our concern simply is to make sure that any sewer or well that is put on the site doesn't infringe upon our ability within our limited site and our setbacks to continue to be able to move forward with our plans to winterize the property, have a well, have a septic. So it wasn't discussed. I assumed it would have been picked up by the CEO that there would have been an infringement upon our ability to do something, and it would have been brought up as a variance. But if it's not, then that's fine. We just wanted to make sure it was on record that
Sure.
there wouldn't be any kind of a conflict moving forward.
Okay. So would it be fair to say that you're here speaking like in neutral, perhaps, for it? Okay.
Absolutely. That'd be a good way to put it.
All right. Thank you.
Yeah, sure.
Is there anybody else here tonight that would like to speak on behalf of this application? Or for, against, or neutral? Okay, so we'll go ahead and close out public comment. So before we start looking at the ordinances, is there anything, Patricia or Tom, that you would like to ask before we start getting into the ordinances? Or
No.
Greg?
Just to clarify, the gentleman that just spoke is the Perry site. That's okay. Just looking at the map, I wanted to, yeah.
Okay, so this whoop,
Hey, David, I have
Yes.
one question.
yeah, go ahead, please.
Can have Sarah or whatever clarify who actually owns the property? She referred to her brother.
Yeah. So my brother and I do own the property.
Okay, so have we heard from the brother?
He is in full support.
And do we have anything in writing that says that?
No, but I can definitely get that.
Okay. And what does the registry of deeds show for ownership of the property?
50-50 ownership between me and my brother.
Okay. That's first questions. So go ahead, David.
Okay, that's a good question, Tom. Sandy, can you confirm that the brother would have been aware of tonight's meeting?
Yeah, when the notices went out, his name was on it, so.
Okay. Yep,
As far as we know, yes.
okay. So just so you know, Tom, he was aware of tonight's meeting, so.
Yeah, it's his name's nowhere on the application.
Right, yep. Did you have anything, Patricia, to ask before we started going through the ordinance?
Nope, but that's interesting catch, Tom.
Is there a statutory requirement that we're not covering in the setback reduction for applying for something like this that requires more than 50%?
Well, so you guys need to establish right, title, or interest in the application. So she, in my opinion, does have sufficient right, title, or interest because she is an owner of the property. You know, this does come up with building permits, for example. If a husband and a wife are on a building permit application or on a deed for a property, and the husband applies for a building permit, we don't go and seek permission from the wife because she's on the deed. We say, okay, you are an applicant, you have sufficient right, title, or interest as the owner of this property. Another example would be a trust. If someone is, you know, the person in care of a property, if it's a land trust or, you know, some type of LLC, maybe there's lots of LLCs on the lakes and stuff, we don't go and seek permission from everyone on the board, or, you know, we take that one person and do they have sufficient right, title, or interest in the application. So it's up to you guys to decide if she has sufficient right, title, or interest as a person, you know, with ownership of the property.
Well, I guess before we even proceed any further, do we believe that Sarah has sufficient right to be here tonight to ask for this without her brother? Tom, what are your thoughts on that?
Having never dealt with it before, my concern is that we're, you know, voting on something that she only has 50% ownership in.
I guess from my perspective, given what Alex has said, I'm okay with her being here tonight, moving forward with this. Greg or Patricia?
So the house is gonna be in her and her husband's name, and the land is in her and her brother's name?
It'll actually be in mine and my brother's name.
Okay. Well, then I'm fine.
Sorry. I don't know if this mattered or not, but I mean, it's a 3-bedroom house, and there's sort of 2 master suites with the idea that he would come in the summer, have access to it in the summertime. So that's why the design is the way that it is. So.
Is this something we can condition our way out of? I just
Right now.
this seems like such a technicality. Like,
If that makes you feel better, yeah, absolutely.
but
Yeah.
yeah, maybe then, if you're interested in mine, I think like maybe we can proceed, and then if there's conditions we want, that's something we can if we think we're about to approve it, maybe add as a condition of some sort of, you know, just
Yeah.
like, let's just get a checkbox from the brother at least, saying, yeah, I'm aware of what's happening to my land and I approve it.
Sounds good. So we'll go ahead and move forward with the ordinances. Because this is shoreland, we'll be looking at the shoreland zoning provisions. Section 16, administration, subsection F, it states that the Board of Appeals may grant reductions from the minimum setback requirements set forth in section 15A of these provisions according to all of the following criteria, and to confirm that this application is specifically for a setback reduction. And also, for the record, I should have stated that a site walk was done on this property on Saturday, October 16th at 9 a.m. In attendance for the board were David Murch, Tom Hennessy, and Greg Dean. Patricia Beaton was unavailable. Also there was Matthew Holland. Unavailable was Sarah Holland. So again, getting back to our shoreland zoning provisions, section 16, subsection F, item 1, says setback reduction appeals are only available to reduce the minimum requirements for setbacks of structures from lot boundary lines. Setback reduction appeals shall not be used and are not available from boundaries of water as provided in these provisions. Their application request is for a 15-foot front setback, a 10-foot side setback, and I don't have it here, but we also received confirmation from,
Jeffrey Callanich.
what's that?
Jeffrey Callanich.
Yeah, thank you, that,
You're welcome.
what is his department? I'm spacing it right.
DEP.
DEP did not, I'm not spacing it on this, the DEP did not have any issue with this, so. Given the fact that they are looking for a setback reduction only from the front and the side, and not from a body of water, I am of the opinion that this condition has been met. So Patricia, are you in agreement?
Yes.
Tom?
Yes.
Greg?
Yes.
And I as well. Item number 2. Now, I want to make a clarification for you on this, okay? If you were to go to the Town of Raymond website today and you looked up the ordinances, you would see land use ordinances. And that was last updated on June 4th, 2019. So if you pulled down that ordinance, shoreline zoning provisions, last updated June 4, 2019, you would pull that down and you would see that item number 2 is worded differently than what the actual ordinance states. In July 14th of 2020 at the town meeting, and you will also find this on the Raymond website as an item underneath shoreline zoning provisions as change voted at the 7/14/2020 town meeting. Section 2, which was voted upon, states that setback reduction appeals may only be granted and are only available for lots with an existing residential dwelling as the principal structure. So the key word that was added here was existing. So given that this is an empty lot, I don't see how this item can pass, but I will leave that for discussion. Anyone?
Well, I can jump in if you want.
Sure.
I'd say you're correct. I think the only way you guys can look at this is if you were to review it as a variance and review hardship, which I believe you should have an email from Phil, the town attorney, on how that would need to be done. But yeah, I think that kind of takes care of this one, I think.
Yeah, I think, unfortunately, we have pretty strict, strictly have to follow the ordinances. There's not a lot of interpretation outside of an existing residential dwelling that I can see could make this pass.
I mean, sorry. I'm just thinking, what we tabled for Port Harbor Marine, we had a question on what is the definition of structure, inside a structure, but I think this, in the sense that we see specifically how the wording was changed to an existing, it was very clear that they are looking for an existing residential structure. So, but do you have something more?
Well, I wanted to clarify the variance aspect of this.
Mm-hmm.
The appeals are obviously different appeals, like appeal for a variance, and this is something we'll probably get into next month too. But
yes,
does this appeal, because it's the same property, affect the ability to appeal for a variance for the same issue?
If you deny it, yes.
If we deny it,
yep.
So could we table this into perpetuity?
They would have to withdraw.
Okay.
And just resubmit, and ideally submit their thoughts on how they meet the hardship criteria.
Because I'd hate to.
Yes. Yeah.
I'd hate to, because of what is basically a very unfortunate timing situation, disapprove this, and then you have like a year you have to wait.
Yeah, I would hope you don't do that. Yeah.
Yeah. So just want to okay. That's all I was looking for.
Yeah.
So for Matthew and Sarah, just to be clear, if we were to vote on this tonight, we would likely have to vote no to your request. And as a result, that would mean you would have to wait a year in order to make another request. An alternate avenue within our ordinances is there's two ways to get a setback a reduction, one of which is which we went through tonight, another is through a variance appeal, which Alex has mentioned. It's got 4 levels of undue hardship, which have to be, we have to get responses to. And those are then evaluated to determine whether or not undue hardship does exist, and as a result, a setback request can be granted. So the setback variances typically are intended to be not the rule, but rather the exception. So you'll have to go through, if you decide to, those 4 criteria and you know, provide evidence that there is undue hardship.
Can we withdraw right now?
Unfortunately, no. We did reach out to the town attorney just to see if there were a circumstance like this that came up. And we're not allowed to sort of change it on the fly. Specifically, we're told the board should not allow an applicant to change an application from one request to another during a public hearing because there are different standards that apply. And both the applicant and the members of the public should be given the opportunity to be prepared to address those standards. So instead, the applicant could withdraw the application for a setback reduction prior to any decision by the board, or request a tabling so that they can decide how they would like to move forward. So
I think he was asking for the
Right.
latter.
Could
I think
they
he wasn't
withdraw
asking
it
to change it.
now on the record?
Oh,
Yeah,
if
he
that's
wasn't
what you're
asking to change it, yeah.
Oh,
Yeah.
if you're asking to withdraw, Sandy would be happy, would the one have to tell me, but.
I mean, that seems like the best course of action as far as I can tell at this point, because there's no way around this ruling, and I don't want you guys to waste time in tabling something that is going
Right.
to be probably withdrawn later, so.
So just to confirm, Sandy, if they are to withdraw tonight, what are their next steps for Alex? Sorry.
Go ahead, Alex.
Um,
Because like you say, they have to meet the criteria for the hardship.
Yeah, essentially you would just have to resubmit the top page with variance checked, and then there's a page 3, I believe,
Yeah.
which has hardship criteria. You just have to answer the questions for that.
And
Now,
then just bring me the copies again.
now the other thing is the fee. I don't feel great about charging them the application fee again. So I don't know how that has worked in the past. I don't know if we've done that with you and I yet, Sandy.
No, we haven't.
I don't know that the board has the ability to waive the fee. I think it has to be the select board. But I will look into that tomorrow because.
Can a butters waive notice? Because the fee is primarily for.
No, that we're required to
Okay.
do by law. So that we have to do. So there is an expense there.
Right.
But Sandy and I will research that one and take a look. Is the board in consensus though that we'd rather not charge them the application fee again,
Remember for sure.
just to come back?
I mean, I would, that was one of my questions was, can we find a way to
Yeah,
make it so
I-
they don't have to be charged?
Personally, I
But
don't feel good about that.
that's
so.
my thoughts, but Greg, Patricia, Tom,
I agree, I would hope that they wouldn't have to be charged again.
Yeah.
Yeah, I think it's kind of
Yeah, I agree.
baked into the circumstances of,
Yeah.
you know, this is kind of a gotcha amendment that was made a couple months ago. And
Has anything else 1 through 8 been changed? Just number 2.
No, just number 2.
just number 2.
Yeah.
Yeah. And I don't know why it was changed, to be honest.
Okay.
It happened before I was here.
I think, it's my understanding, it was to bring it in consistency with what's the criteria in land use.
Oh, okay.
It says existing in land use.
Yeah.
Like,
Well, that makes sense.
yeah. But yeah, I don't think we're of any interest in trying to seek
Yeah.
as so much as we can control that.
Yeah.
Doesn't seem like there's much.
Okay.
Okay,
And-
so to confirm, you're gonna withdraw your application tonight.
Yes. And we've missed the deadline for the next meeting, is that correct?
Yes,
Okay.
that's also true.
All right.
Okay,
We'll see you
sorry,
in two-
but
2
Yeah.
months.
at least it's not blocked for a whole year.
Thank you.
Right.
Okay. All right, I've lost my agenda sheet. It's gotta be code enforcement communications. That must be the next.
You got it? Yeah.
Yes.
Yeah. I don't really have a whole lot to communicate. We do have our session with the attorney next month. So I don't know, Sandy, you've talked with, is it Phil that's doing theirs? Phil's doing theirs,
Yes,
right?
Phil's
Yeah,
doing theirs.
Mary's doing planning board.
Correct.
Should they come with questions? Has he asked if we want to send him some topics or?
He hasn't, but what we did with planning board was we told them if they wanted to send questions to me, and then I would put it all together and forward them to Mary, which I did. You know, that's probably the best way. That way we know what you're looking to. So we
Yeah.
have an idea what they're gonna be needing to talk about.
Yeah, so I know you guys have come across a few trouble spots in the ordinance. So if there are things that you would like to kind of go over with the attorney, you can send those to Sandy and we'll make sure that he gets those and can come prepared. I think you'll find it's going to be a good use of time for sure to go over some of those things.
So to confirm, he's going to have a presentation already prepared for us, and then he'll
Yeah.
supplement it with questions, or?
Well, an attorney will talk as long as you let them. So, yes, he frequently gives these type of trainings, presentations to ZBAs. So he does kind of have a standard boilerplate, recap of the hot topics for a ZBA.
Right.
But if we send him some questions, he'll probably
If you have
tailor that.
something that's bothering you with specifically the way it's in the ordinance for, like this with the setback.
Setback reduction and
where
variance, yeah.
We've got it with that little chart, and then there's the other wording, so that's probably what that to address.
Yeah,
Which, like you say, Alex, that was before us. Neither one of us even knew about it.
right, yeah. So I would say, for example, that's a good one, the setback reduction versus variance thing that we've kind of talked about.
Right.
Things like that, he can talk about that instead of, just the standard ZBA stuff, making sure you don't drive by on your own and go do your own,
Right.
site visit.
And that would be, if you submit questions, they won't be the only questions you can ask him. When he's doing the presentation, if something comes to mind, write it down, and then when he does questions,
Yeah,
ask it then. Or at least that's how Mary's going to do it. She's going to
Yep.
do her
Yeah,
presentation,
he'll do the
address
same
the
thing.
questions that we've sent to her, and then if the board has other questions, she'll do a Q&A.
yeah,
He may want you to question it as he's addressing the subject. I don't know.
yeah, we'll go over that once he is set up and ready to roll.
Okay.
But that's pretty much it. We've got some more administrative changes coming. Good changes, though. So we'll be rolling that out in the next couple of weeks. And yeah, that's pretty much it. We're starting the process with ordinance amendments for the planning board in December. So we'll be rolling on that in December, January, February. And we've got a lot of stuff to go over with them for solar, marijuana, all sorts of good stuff. So it's going to be a busy winter. The ordinance amendments, that is currently being worked on. So we did, I've mentioned before, that was approved last year, and we are now in process with them. So they say a year. We'll see how long it actually takes, but we should hopefully be getting a status update from them here. I think they do. It takes a couple of months to get set up and rolling, and then they check in and give you kind of a status report. So I'll let you guys know if I hear more on that.
Can you clarify what you mean by that, the ordinance amendments?
Yep. So all of the ordinance amendments, the ones that you're talking about, for example, on the website, we've hired a company called General Code to codify and review the ordinances and update them.
Okay.
And that'll be an annual thing. So they'll be kind of in an online code library on the website. As we update the ordinance every year, we send updates to them and they just update it, instantly within a month. And so that'll avoid us having the issues of outdated PDFs on the website.
And Alex, will that be the same as like when they did it when we were in Casco?
Yes, same company.
So it'll be a searchable
Yep.
document,
Yep.
which
Yep.
is awesome.
Yeah.
It's a pretty nice tool. I mean, you can print certain sections, focus on certain sections. You can search across a whole bunch of different things.
Will they be looking for, I mean, like David is fairly skilled at identifying these kind of perhaps logical or kind of inconsistencies that are hard to unwind in real time, and are they going to look for flag things like that as well?
Yep,
or it's just kind of paralyzing for us. We're like, I don't know what a structure is. Let's move on.
One of the things we did is we did out on the premium, option they offer, which is a legal analysis. And so they go through the ordinance and they do find the issues.
No.
We did it in Casco, and it was like 100 and something page document of all of the issues.
Yeah.
And it was small font. It was like a 8 or 9 font. And so it's pretty in depth.
Great. I think that'd be really helpful.
Yeah, that's why it was worth it. I think it was like $3,600.
Yeah.
I think we just did shoreland and land use, if I remember correctly, but it's well worth.
Seems like we pay a little bit of that. It's that it's just spread out over all the town's meetings. It's every.
Yeah. I mean, it's there's a lot of issues in the documents with definitions. For example, the definition that's missing for the outdoor sales, little things like that. Quirky. So hopefully this will give us a good starting point to kind of move forward for the next few years.
Well, that sounds good. I remember all the craziness just with manufactured homes some years ago. We had to throw a moratorium up just so we could figure out the wording and definitions, and that was a nightmare. That was a nightmare.
Yeah, I've heard a little bit about that.
Have we seen anything that's coming up for the agenda? You had indicated Chris was going to start addressing violations.
No, I don't think anything coming to you guys. We're currently dealing with one of the, actually, Chris and I both agreed it's the largest shoreline zoning violation we've seen ever, probably, on Sebago Lake right now.
Nice.
It's pretty substantial, so that one will probably be most likely seeing some local newspaper at some point. You'll see DEP is getting involved, and actually what I've heard is DEP is actually going to take some enforcement action, which is very uncommon nowadays. So it's pretty serious. So no, I don't think there's anything coming to you guys in the next few months yet. But there's always the possibility that, for example, they could appeal the NOV and then come to you guys, but I highly doubt they will. So we've got quite a few violations that we're working on right now. It's been busy.
Okay. All right. Well, thank you.
Yeah, no problem.
So for the planning board, you said December, January, February. So you got my stuff about the.
Yes.
Thank you.
Yep.
Does it make sense to ask the planning board to clarify what outdoor sales and services are, or at a minimum clarify that within a structure so that we don't bump into this?
If you want to tack that on, then that's fine.
Okay.
We can create a definition for that this winter. That's a pretty easy one, I think.
Yeah,
Well, easy. They aren't easy ever, but yeah, I think if you want to send that to us, we can add that to your list. It makes sense. I was going to suggest that earlier, but I forgot. So,
Okay.
yeah.
I'm good. Okay, so motion to adjourn.
I'll motion to.
Second.
Seconded.
All those in favor? Patricia? Tom?
In favor.
Greg?
Agreed.
I'm in favor as well. Good night, everyone.
Good night, thank you.
Good night.
Good night.